Hey there, everyone. I'm Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about whether a disabled individual can be your executor or your personal representative or your trustee. So an important element in creating an estate plan is choosing a responsible party to handle your legal and your medical and your financial affairs if you become unable to manage them for yourself. So for example, if you become incapacitated or when you later pass away. The individual or the entity that you choose must be someone that you can trust to make crucial and oftentimes time-sensitive decisions. You want someone who's detail-oriented and transparent with those who have a right to know how your property is being managed and used, and someone who is going to be ethical and fair to all of those who have an interest in your welfare and ultimately your property. Now, most estate planning in the United States utilizes a combination of trusts, powers of attorneys, wills, healthcare directives, and similar legal documents. Now, each of these documents designates a person or an entity to carry out certain legal duties as spelled out in the document. So these are often referred to as fiduciary duties for the person who creates and signs that document. Now, these fiduciary rules have different names depending on the type of document that grants the authority. So let's take a couple minutes to review the legal documents and the fiduciary's role or the title that's related to them. So first you have your last will and testament, or perhaps sometimes it's just called a will. And the person who's in charge of managing that, or the person that you have to choose, and what they're called, is an executor or a personal representative. Now the terms mean the same, they just have different titles or names, and that's dependent on state law in the state in which you reside. So the next document you have is a trust, and the person that you choose to be in charge of that trust or manage all of those assets, that legal name is called a trustee. And next you have your power of attorney. So this is a financial power of attorney. And the person that you choose for that is often referred to as an agent or an attorney in fact. And then last but not least, we have your healthcare power of attorney. And the person that you choose for that is often called a healthcare agent, and sometimes you'll see, depending on the state you live in, they're called healthcare surrogates. So in choosing someone to take on these responsibilities or choosing a fiduciary, there are some legal requirements. So to help you illustrate why it's the requirements that we have, we can examine what's called the Uniform Trust Code. And this is just a model legislation that's been adopted in some form by about 35 states. And although the laws actually vary on certain points once they become adopted by the differing states, there are generally similar rules or facts that are related to them that provide us with guidance on the duties and the responsibilities of a trustee across the country. Now, many of the states that have not adopted the Uniform Trust Code, they have provisions in their trust and probate codes similar to those that are found in the Uniform Trust Code and Uniform Probate Code with respect of who can be named a fiduciary. Now, the Uniform Trust Code does not establish a specific legal test for qualifying someone to serve as a trustee. The only requirement is that they accept their duties either in writing or by simply performing the duties of the trustee, or otherwise indicating acceptance of the trusteeship. Thus, if an individual names a disabled person as their trustee in a Uniform Trust Code state, the named person would be perfectly within their rights to act in that capacity as long as they could accept the appointment in writing or begin acting in the role of a trustee by adequately carrying out their duties regardless of any disability that they might have. And in fact, if any state laws prohibited someone with a physical or a mental disability from acting in a fiduciary role merely because they had the disability, that prohibition could easily run afoul of the Americans with Disabilities Act, which is federal legislation designed to prevent unjustifiable discrimination against individuals with disabilities. But what if the named person does not, in fact, have the physical or mental ability to carry out their duties? Well, in that case, the Uniform Trust Code does provide clear guidance as it specifically addresses removing a trustee who is proven to be incapable of carrying out their responsibilities. Now, Section 706 of the Uniform Trust Code provides that a trustee can be removed upon request of a co-trustee, a grantor, a beneficiary, or the court itself because of unfitness or unwillingness or a persistent failure of the trustee to administer the trust effectively. Now, most states have laws similar to the Uniform Trust Code with respect to the nomination or removal of an individual in any fiduciary role that might be found in an estate plan. So let's talk about some practical considerations. So from a practical perspective, if you understand the duties of a trustee or another fiduciary, and you feel that the person you plan to nominate to serve in that capacity can reasonably carry out these duties, then you have every right to name that person to serve in that role, regardless of their disability. For example, if your executor is a blind or a deaf adult child, you should ask yourself whether their particular disability will seriously interfere with their ability to carry out their responsibilities in that role. If you're not sure what those responsibilities will be, just ask your attorney to explain it to them. And once you better understand the role, then you will be better prepared to answer that question. If your preferred choice for trustee or executor has a disability that will in fact interfere with their ability to carry out their responsibilities, the next question to ask is whether they can obtain sufficient assistance through technology or other means to carry out their duties. If so, then they may still be the best choice for you. So the bottom line is that a disability in one area, such as a blindness or a hearing impairment, may have very little impact on an individual's ability to carry out the necessary duties of a fiduciary, particularly if they're able to obtain assistance to reduce any obstacles that might otherwise prevent them from fulfilling their role. In fact, failing to consider a trusted family member or a professional simply because they have a disability could needlessly deprive you of the perfect choice for that crucial role of trust and stewardship that is so important to successfully carrying out your estate plan. So I want to thank you for watching. I'm Kelly Longtin from Kelly Longtin Law.